Hello everyone, myself Sourav Sharma, and today we are going to talk about bonded labors. So firstly, let's talk about what exactly is bonded labor. Bonded labor is a system in which borrowers are forced to repay their loans through labor. Here the employers give loans at very high interest rates. As the loan amounts to be repaid are unreasonably high, the time required to pay off is very large, thereby creating a vicious cycle of generational inequality. Bonded labor is also known as Bandhua Mazduri or debt bondage in India. At a global level, India was ranked 4th position in 2016 Global Slavery Index. Now, history of bonded labor. The origin of bonded labor can be tracked back to ancient time whereby the Hindu society was divided into caste structures. The lower caste strata did not have sufficient means for their own sustenance, due to which they often depended on higher caste for their own survival. Due to extreme scarcity of resources on the part of debtor, he had nothing to offer as security. Thus the creditor and debtor entered into an agreement where the debtor pledged his person and work in lieu of unsatisfied debt. There still exists in different parts of the country a system of usury under which the debtor or his descendant or dependents have to work for the creditor without reasonable wages or with no wages in order to extinguish the debt. At times, several generations work under bondage for the repayment of a paltry sum, which have been taken by some remote ancestor. The interest rates are exorbitant, and such bondage cannot be realized as a result of legitimate contract or agreement. The system implies the infringement of the basic human rights and destruction of dignity of human labor. Apart from various constitutional provisions, there is a specific legislation to prohibit bonded labor. This is the Bonded Labor System Abolition Act 1976. Bonded labor system was as defined in the Bonded Labor System Abolition Act 1976. Bonded labor means any labor or service rendered under the bonded labor system. Now, some judicial interpretation enforcing the constitutional provisions bonded labor. The Honorable Supreme Court of India has from time to time interpreted various constitutional provisions to safeguard the weaker strata of society against the menace of bonded labor. Some of them are enlisted here. These are People's Union for Democratic Rights versus Union of India, Bandhua Mukti Morcha versus Union of India, and NEERJA CHAUDHARY versus State of Madhya Pradesh. Now, firstly, let's talk about first case, People's Union for Democratic Rights versus Union of India. The petitioner commissioned three socialist scientists to inquire into conditions under which the workmen worked in Asiad projects. Based on the investigation conducted by social scientists, petitioner sent a letter addressed to Justice P.N. Bhagwati in pursuance to the same. The Honorable Supreme Court took notice to the letter on the judicial side and issued notice to the Union of India and State of Delhi. The court held that the Union of India, the Delhi Administrator and the Delhi Development Authority cannot escape the obligation to the workmen to ensure observance of the provisions of the various labor law by its contracts and non-compliance with the laws by the contractors. The workmen would clearly have a cause of action against them as a principal employer. The Honorable Supreme Court of India dealt with the expression other similar form of forced bonded labor emphasized in Article 23 of the Constitution of India 1950. The court gave the expression a wide interpretation to meet the objective of the Article 23. The court held that a person who has been forced to work as a bonded labor and a person who is working as a labor at a rate lesser than the minimum wage shall be dealt equally. Now, on the second case, Bandhua Mukti Morcha versus Union of India, The public interest litigation was filed before the Supreme Court under the Article 32 of the Indian Constitution to issue appropriate directions for prohibition of the bonded labor. The petitioner conducted a survey in stone quarries situated in Faridabad district. It was found by the petitioner that they were living in substandard conditions. There were a lot of middlemen who extracted the money from the workmen as a commission. The court directed the central government and state of Haryana to install washroom, suitable drinking facilities, provide medical kits so as to raise the living standards of the workmen. The court directed the central government to conduct inspection every fortnight, and in case of any workman is found in discreet conditions, he should be provided medical and legal assistance. The court went to observe that this right to live with human dignity enshrined in Article 21 derives its life breath from the directive principles of state policy, and particularly Clause E and F of the Article 39 and Articles 41 and 42 at least. Therefore, it must include protection of the health and strength of a workers, men and women, and of tender age of children against abuse, opportunities and facilities for the children to develop in a healthy manner and in conditions of freedom and dignity, educational facilities, just and human condition of work, maternity relief. These are the minimum requirements by which must exist in order to enable a person to live with a human dignity, and no state, I repeat, no state, neither the central government nor any state government, has right to take any actions which will deprive a person of the enjoyment of these basic essentials. Now, if we talk about the third case, NEERJA Chaudhary vs. State of Madhya Pradesh, it was alleged by the petitioner that in spite of the fact that a long time has elapsed, quite a number of the labourers rescued from Faridabad quarries have not been rehabilitated. It was contended by the petitioner that the state government has obliged to overlook the rehabilitation of the rescued labourers, and rehabilitation of the labourers is necessary so as to ensure right of life granted to them under the Constitution of India 1950. The Honorable Court held that as per the requirements of the Article 21 and 23, the bonded labourers need to be identified, rescued and also rehabilitated. The court highlighted the importance of rehabilitation, observing that in absence of any concrete measures for rehabilitation of rescued labourers, they would be driven into the state of poverty and substandard condition. Again, it might lead them to the bonded labour system again. Now, if we talk about statutory safeguard against the bonded labour, the Bonded Labour System Act 1976 provided various safeguards against bonded labour. Some of them are enumerated below, such as under Section 4 of the Act, the primary relief that was awarded to the bonded labourers with the commencement of the Act was the bonded labourers stood discharged from any sort of obligation to provide bonded labour. Under Section 5 of the Act, any custom agreement whereby bonded labour existed was rendered void and inoperative. Prohibition was casted on institutions of any suit before any civil court recovery of bonded debt. Every decree or order of the recovery of bonded debt passed before the commencement of the Act and not fully satisfied before such commencement shall be deemed on such commencement to have fully satisfied. Under Section 7 of the Act, any property which is under mortgage or vice versa bonded debt shall stand freed on the commencement of the Act. Any person detained in civil prison in pursuance of the bonded debt shall be freed as per the provision of the Act. Under Section 8 of the Act, a bonded labour who has been freed shall not be evicted from homestead. Bonded Labour System Act in 1976. Some of the main and silent feature of the Act: totally abolishes the bonded labour, to identify and rehabilitate bonded labour, to identify certain scheme on committees to be formed at the district level, punishment of up to 3 years, punishment or fine, imprisonment or fine. Any attachment of the property of bonded labourers stands cancelled from the date of enforcement of the Act.